the pre-incorporation contract concept. See, it is like a person who is getting into contracts, okay, before the company is into existence. But whatever activities he is doing it on behalf of the company. Hence, I can say that he is actually acting as an agent for the company. So a land that he purchases for the office premises of the company is not going to be in his own name going forward. It is going to be in the name of the company. The company is going to own the property. Okay, so he is just an agent who is completing some activities before the incorporation of the company. Okay, and hence a promoter acts as an agent to secure the assets of the company. Okay, but an agent must have a principal. Our agency concept in Indian Contract Act says very clearly, if there is an agent, there has to be a principal. Okay, but in this case, the principal, that is the company, does not exist. If the principal does not exist, then the question arises, who will take the liability of the acts of the agent? Okay, normally the agent does not have the liability. He acts on behalf of the principal and the principal has the liability. But in this case, since the principal does not exist, the liability will be in the name of the agent. Who is the agent? The agent is the promoter. So promoter will be liable in cases of pre-incorporation contracts till the company comes into existence. And there is one more condition which has been added, that the company should ratify the pre-incorporation contracts and adopt those contracts. Understood this background or this concept? Now let us understand the life cycle of pre-incorporation risk. We have understood in the last few minutes that the pre-incorporation contracts, the liability lies with the promoter till the company does not ratify and adopt the contracts. Correct? So initially, when the company is in an idea phase, okay, where the promoter is doing all the activities to bring the company in its form. So whatever contracts have been entered by the promoter, there will be 100% promoter's liability, 100% promoter's personal liability. Okay. Now my question is, once the promoter incorporates the company, does the liability shift to the company? The answer is still no. The answer is the promoter will still be liable. Why? Because promoter will be liable till the company ratifies the agreements or the contracts and adopts the contracts. And how will the company do this? The company will do this in the first board meeting. In the first board meeting, where they will pass a board resolution to adopt the pre-incorporation contracts. Now there are some conditions and procedure involved in this thing. I'll come to it in a bit. But have you understood this life cycle? Simply, in the idea phase, 100% promoter personal liability. In the incorporation, again 100% promoter liability. But once the ratification is done, the contracts will then become contracts of the company and the promoter will not be liable. As once the ratification has happened, liability shifts to the company. Okay. Now, in Specific Relief Act 1963, Section 15 and Section 19 have provided about adoption of pre-incorporation contracts by the company. The company will adopt the pre-incorporation contracts. First condition is that if it is provided in the Memorandum of Association and in the object clause to adopt the pre-incorporation contracts. Second, the Articles of Association have given the power to the board to adopt the pre-incorporation contracts. Third, such contracts are in the benefit of the company. So in that case, the company ratifies the contract after incorporation in the first board meeting. Then we can say that the pre-incorporation contracts have been adopted and the liability now shifts to the company. So there is a famous case law for this concept of pre-incorporation contract. In fact, there are around 4 case laws which have been provided in the ICSI module. Okay, so go through all of them because it is an important topic from the examination point of view. But for this particular lecture, I will just touch upon the case law of Kellner versus Baxter. What happened in this case is that Kellner, a supplier of wines, got into a contract with 3 persons, A, B and C, who were incorporating an hotel company. Okay. Now A, B and C received the wines, that is goods, from Kellner, but as soon as the company was incorporated, the company collapsed, the hotel collapsed, and the question now arose that who will provide or who will be liable for the payment of money against the goods provided by Kellner. Kellner contested that A, B and C, the promoters, should be held liable, and the ruling was that A, B and C are personally liable. No subsequent ratification relieves them without Kellner's assent. So one important concept comes out from here is that even though the company has ratified, the supplier or the other party to the contract must also give his assent to such ratification. Okay. Otherwise, A, B and C, all three in this case have been held personally liable. Okay. Go through the other three cases also. Now the last part is that what is the procedure for ratification of pre-incorporation contracts? Procedure is, the first point is that the memorandum of association of the company in its object clause shall provide for adoption of the pre-incorporation contracts. Okay, that's point number one. Point number two, the articles of association should also empower the directors to adopt the contracts. That means to pass a resolution to adopt the contracts. Okay. So first is memorandum of association, second is articles of association. The third step will be prepare statement of all incorporation contracts and amounts. So we will consolidate all the pre-incorporation contracts and the amounts which is there against each contract. Then convene the first board meeting with notice, present the statement. Okay, and the chairman initials the statement, board passes resolution adopting the contracts. This is the procedure, 5-step procedure in which the pre-incorporation contracts will be adopted by the company, and once it is adopted, the liability shifts from the promoters to the company. Okay.